Hi, everyone, and welcome to today's Germination Retail Roundtable webinar. My name is Mark Zinkowitz, and I serve as editor for Germination, and I'm happy to be your host. Today's theme is intellectual property. We'll hear from two experts who will offer insights on this topic and what it means for you. Before we begin, I'd like to thank our sponsors, 2020 Seed Labs, Canterra Seeds, and SeCan for their support. We'll be doing some live tweeting during the proceedings. I encourage you to engage with us on Twitter by following the hashtag #SeedRetail as we go along. Today's webinar is being recorded and will be made available at germination.ca following the event. During the presentations, you'll no doubt have some questions for our speakers. Please type these into the chat box at any time and we'll address them during the Q&A sessions we'll hold after each speaker finishes their presentation. If we don't have time to take all questions, you will receive an email response. Intellectual property, or IP, is important to the seed industry for reasons I don't have to explain. IP underpins innovation and enables plant breeders and seed companies to stay in the business of plant breeding and seed and helps safeguard the hard work of breeders so that they're able to protect the innovations they bring to market. Our first speaker is Anthony Parker, Canada's Plant Breeders' Rights Commissioner, who will talk about the importance of plant breeders' rights and intellectual property and things you should know regarding it. Take it away, Anthony.
Well, thanks very much to Germination. It is a real pleasure always to come and chat about plant breeders' rights. The area I'd like to focus on today is just a reminder, a prompt about plant breeders' rights and what you should know. So if we move to the overview, a few things I'd like to cover in my presentation today. Why is plant breeders' rights intellectual property protection important? What is the International Union for the Protection of New Varieties of Plants, otherwise known as UPOV? And what are my PBR rights when I've obtained protection on a variety? So first we cover the topic of, well, why is PBR important? One has to realize that plant breeding is a very time-consuming and resource-intensive activity, often taking about 7 to 12 years to develop a variety. More recently, we've learned about $2 million minimum to develop an agricultural variety. It takes specialized personnel and equipment, so a lot of upfront investment before bringing a variety to the marketplace. But the thing about plants is they can quickly and easily be reproduced. So there's a high probability that someone could take that innovation, use it without permission, or fairly compensating the innovator, the breeder of that variety. Now, sometimes PBR gets confused with things like variety registration. One has to understand that PBR is very similar to other forms of intellectual property protection like patents or trademark. So it's voluntary. No one forces an individual or a company to get plant breeders' rights. They obtain those rights because they perceive it gives them a good value proposition. So if a breeder is successful in obtaining plant breeders' rights protection for his or her variety, they have a suite of private rights that they can enforce in the marketplace. And if the system works well, they can be fairly compensated in the form of a royalty. Now, here in Canada, in the agricultural crops, that tends to be a royalty embedded in the price of certified seed. For other types of commodities that are protected, let's say in the ornamental sector or in the horticulture sector, often that is a royalty on each plug of a plant or each plant that's sold into the marketplace. So what are the benefits for breeders when you obtain plant breeders' rights? Well, you can enter into license agreements with growers, propagators, and retailers, and you can define the terms and conditions of those licensing agreements. If something happens in the marketplace, if someone infringes on your right, you can take legal action against unauthorized propagation, sales of your variety, and you have a way of exercising control over the propagating material as it moves through the value chain and try to prevent it from being stolen or illegally propagated. And as I mentioned earlier, in the agricultural crop types, a royalty tends to be charged on every bag of certified seed that is sold into the marketplace. And if the system works well, royalties can recoup that initial investment. As I mentioned earlier, that 7 to 12 year lead time where you do your crossing and all your selections, and you have a lot of investment there. And it creates an environment that encourages further reinvestment into breeding programs. So it also has to be understood in Canada that this is a really important tool to support not only public breeding programs, but private breeding programs, as well as partnership models that we often see. Well, are there any benefits for producers? Well, of course there is. Again, if the intellectual property environment functions well, it fosters investment in a competitive marketplace. So it gives both public entities and private entities confidence that they can make these long-term investments in breeding, that 7 to 12 years before you can release a variety into the marketplace. It incentivizes breeders to develop better varieties, so it stimulates that competition and building upon previous success to generate future success. So, incorporating new characteristics for disease resistance, stress tolerance, better end-use characteristics for the consumer, but also higher yield. And what we've seen is in countries that have implemented this type of system, we see an increased number and diversity of crops and varieties, so that at the end of the day provides more choice for producers. International harmonization through the system encourages breeders to release varieties into many jurisdictions. So you have the ability to not just have a domestic market for your interested variety, but you can also, if there's adaptability, release that variety into a different jurisdiction internationally. And I'll get into this a little bit later, but it also balances interests both between public and private entities, but also between producer and breeder. So we hear often a lot of misinformation about plant breeders' rights. This is a quote that I obtained from a newspaper clipping. PBR only benefits transnational corporations. Well, that's really not true. Strengthened breeder protection fosters a positive business environment for investing in plant breeding, and that could be any party. It could be public, it could be private, it could be producer funded, or it could be partnerships. And often we see that it's small and medium-sized entities or even micro entities that use PBR protection because it's a very affordable form of intellectual property. And in fact, we've recently crunched some numbers on the applications that we've received for plant breeders' rights. And indeed, over 50% of all PBR applications for agricultural crops come from public institutions. So they can come from the university system, an entity like University of Saskatchewan Crop Development Center or University of Guelph, but also the federal program at Agriculture and Agri-Food Canada and provincial governments such as Alberta. And these royalties can be a very important source of sustainable funding because breeding requires long-term investments. So I mentioned earlier the acronym UPOV, and really what UPOV is an international treaty that Canada is party to. And the purpose of this international treaty is to provide and promote an effective system of plant variety protection with the aim of encouraging the development of new varieties of plants for the benefit of society. So Canada became a member in 1991, and we did so under a previous version of the convention called UPOV 78. And more recently in 2015, we amended our law to conform to the most recent version of this international treaty called UPOV 91. So what happens is if any country wants to become a member of UPOV, they have to have a domestic plant breeders' rights law that is compliant with this UPOV convention. So I mentioned a little bit earlier, one of the benefits of harmonization. If you look at this map that provides a status on UPOV, right now there's 76 countries, those in green, covering all the continents except for Antarctica, covering 95 states which have laws that conform to UPOV. So what this means for a breeder is you can go into any one of these countries to seek plant breeders' rights intellectual property protection, and you would be faced with a harmonized set of requirements. So if you protect it in Canada, well, the requirements under the PBR law would be very similar to those that you would find in France, which would be very similar to those that you would find in Australia. So it really promotes harmonization. It provides a mechanism for breeders to have a high degree of predictability when they apply for protection in countries. And what we're finding is over time, more and more countries are interested in joining this international convention. If you look at both the dark brownish color and the orange color, those are the number of countries that have either initiated developing laws to become part of UPOV or have been in contact with the UPOV office seeking assistance on how to draft laws. So we talked a little bit about why it's important to have plant breeders' rights and what the UPOV convention is. So here's really the crux of the presentation. You know, what are your PBR rights should you get protection? So if you fill this criteria, you go through the application process, you're granted PBR rights. What it does is gives the breeder exclusive rights over several functions in the marketplace. They have exclusive rights over the production and reproduction of the variety, both the import and export, any sales, including advertising, the ability to condition, the ability to stock a variety, the ability to collect a royalty, and they can enter into licensing agreements or even sub-licensing agreements to authorize conditionally or unconditionally any of these functions. So what that means is, for instance, an entity like AFC might get intellectual property protection, but then they might license their variety to an entity like SeCan or Canterra to sell that into the marketplace. They might even identify a different entity for any export sales of that variety, and they might even do defensive filings in another country to prevent the import, the illegal import of that variety into a country. So it's really a very useful tool to maintain a degree of control and ensure that your intellectual property is being used responsibly. So the minute that in Canada, under the current system, the minute someone files for intellectual property protection and they're accepted for filing, they're given something called provisional protection, and all these rights come into force immediately. There also are some other useful tools that are part of your rights as a breeder. And one of those is if someone illegally obtains seed of your variety and starts reproducing it on a farm, and they've never paid you a royalty, they never sought authorization, your rights are now extended to the harvested material. So what this means is in situations where illegal brown bag sales happen, so, you know, let's say one producer sells a PBR protected variety to another producer, they start generating crops and grain off of that, the breeder can now seek compensation not only for the illegal use of the seed, but any grain that has been harvested. So a pretty powerful tool, a strong disincentive. Shouldn't be buying illegal brown bag sales without, of course, seeking authorization from the breeder and compensating them. The breeder also has exclusive use of the variety name, or what we call the variety denomination, and that's a unique identifier to that variety. For instance, AC Brandon, a very popular wheat variety, the intellectual property protection is tied to that variety. No one else can use the term AC Brandon without the consent of the title holder. And in fact, if anyone does use that term, they would be in violation of plant breeders' rights. So if there's any infringement that occurs, the breeder can seek compensation through the civil court system. So often that's not the first step. There's usually a demand letter that's issued by the breeder to cease and desist any infringement, and then some negotiated terms for compensation. But if that's unsuccessful, they can always seek a remedy through the civil court system. So PBR protection doesn't last forever. It's in force for 20 years for all crop species except for trees and grapevines. And the reason they're 25 years is it takes a longer period to breed. But what we find is that PBR protection often doesn't last the 20 years and it's voluntarily surrendered. So for instance, in cereals, it's about 7 to 8 years that PBR protection generally lasts, and then something better comes into the marketplace, displaces an old variety. The old variety no longer has the same value or sales that it once did, and the breeder will voluntarily surrender that form of intellectual property protection. Now, I mentioned earlier that there's aspects of benefit sharing in the system. It's really meant to be an open mechanism of innovation. Well, how does that happen? One of the core requirements of PBR protection is the breeder's exemption. And what this means is when you PBR protect a variety, someone else can come and use that variety in their breeding program and improve upon it. So we think about something like wheat, this constant cycle of improvement, where we might have an older variety like AC Berry, and then someone uses a PBR protected variety, to develop an even better variety like AC Carberry, and then more recent AC Brandon. What you'll see in the pedigrees of those varieties is often a PBR protected variety that has been used, and the breeder improves. So as a breeder, you benefit from your skill, you would benefit from a bit of time in your breeding activity and creativity, but your own innovation might be used by someone else and improved upon and bettered upon. So what it does is it stimulates a system of continuous improvement. If you want to be in the breeding business, you always have to be mindful that you're releasing something better than you released previously, because your competition is going to be doing the same. The researcher's exemption is a really important exemption under PBR, and what this means is anyone can conduct research on a PBR protected variety and publish those results. So often we see in journal articles, scientific articles, information about a PBR protected variety, its disease resistance, its yield, its quality characteristics, and no one has to seek authorization to do research on a PBR protected variety. Finally, we have two other provisions, the private non-commercial exemption. So if you're not in a commercial setting, you can use a PBR protected variety and not seek authorization. And of course, in Canada, we have the farmer's privilege. So what this means is if a producer legally purchases a PBR protected variety, that producer can save and reuse seed on their own holdings, their own farm, for as long as they wish. Now, this is also the crux of one of the conversations that's happening in the value chain right now, and that's around value creation. So that's about it certainly is not about stopping the farmer's privilege, not about stopping farmers to save and reuse seed. More, it's about every time they do so, should they compensate the breeder back for the use of that innovation? So that's a discussion that's happening right now. And finally, once rights are expired, or as I mentioned earlier, sometimes they're surrendered much sooner than the 20 years, then the variety is considered public domain and there's no restrictions on the variety. So in conclusion, new varieties have tremendous value. They're the culmination of many years of effort and investment. They should be protected. I would argue it's even more important in the public sector because taxpayers have often paid part of the bill for developing a new variety. PBR protection can help prevent misuse of an innovation in the marketplace. And PBR is available to all breeders, and royalties can be an important source of funding for a breeding program. So as I mentioned, not just private entities, but also public institutions rely very heavily on royalties from the sale of their variety to create self-sustaining funding. And it also encourages partnerships. So things like 3 or 4P partnerships where private, public, and producers can come together and fund variety development. Because we're part of a harmonized system internationally, it means there's a high degree of consistency when you're applying into different countries. And what we've seen firsthand here in Canada is not so much in the agricultural space, but in the fruit and vegetable and ornamental sector, where most of the breeding activities happen in other countries. Soon as you have strong intellectual property protection that is harmonized, it gives breeders confidence to release their innovations into Canada. So that benefits our producers and benefits our value chain as a whole. So thanks very much. Really appreciate the opportunity to come and speak to you today.
Thanks so much, Anthony. We'll now take some questions. If you have a question, please type it into the chat box. Remember, if we don't have time to take them all, you will get an emailed response. Anthony, I have a question regarding where people can find the status of a variety and whether it's protected or not. How can they do that?
That's a great question. Yeah, quite often we get questions coming from producers, but also from retailers to say, how can I find out the status of a PBR protected variety? When was the application filed? Is it currently protected? Or, it's an older variety? Has the plant breeder's rights expired on it? What you can do is if you do any sort of web search that is Plant Breeders' Rights Office, Plant Breeders' Rights Office Canada, the first hits will take you to our office website. And under our law, we have to publish the status of all applications that we've received. So you can do a lookup for the crop type or even for the name of the variety on our website, and it will provide you all the details. It will tell you when the application was filed. It will provide you details on the distinctness, uniformity, and stability examination that's been conducted. So those are the fundamental criteria to get plant breeders' rights. It'll tell you when the expected termination date is, so when the 20 years will run up, and it will even tell you if the rights have been revoked or if they've been voluntarily surrendered by the rights holder. So that's really important, because then are the rights in force or are the rights no longer in force? And then there's different things you can do. You may not have to seek authorization any longer from the title holder because it's either expired or the rights have been surrendered.
Anthony, I have a question regarding essentially derived varieties. This person has heard this term quite a bit, and they're not quite sure what it means or how it works exactly. What are the do's and don'ts in regards to that, and what should people know?
All that means is there's a certain provision in the UPOV Convention, and it's also in our own domestic law, that extends the rights of a breeder, the title or the breeder of a variety, to new varieties that have just had minor changes to it. So this is really important in the context of new plant breeding innovations. So the use of technology such as CRISPR, where someone can come along and do some minor edits, gene edits to a very popular variety, and before they commercialize that in the marketplace, they have to seek authorization from the original title holder. So this we believe, is going to be more and more important in future as new plant breeding techniques and technologies become cheaper and easier to use, is that there's going to be greater interest in making minor modifications to some very popular and widely sold varieties. And this concept, called essentially derived varieties, helps protect the rights of that original rights holder. So you're going to see more and more information about that concept coming in future.
Thank you so much, Anthony. Our second and final speaker of the day is Lorne Hadley, Executive Director of the Canadian Plant Technology Agency. He's going to talk to us a little bit about a new method of value creation that you've probably heard of called the Seed Variety Use Agreement, what it is, how it contributes to the protection of intellectual property, and some do's and don'ts regarding IP. Lorne, the floor is yours.
Okay, well, good day. It's Lorne Hadley from the Canadian Plant Technology Agency, here to talk to you about value creation systems and their impact on you as retailers. I guess the big update for 2019 is nothing much has changed at this point, but we're hoping to move towards the SVUA, which is the Seed Variety Use Agreement. So I think in general, as I said, nothing much has changed. Everything that we've talked to you about before is still in place. We're going to ask as the role of seed retailers to be aware of what you're selling. Be aware that you don't sell it to someone that you feel may be not going to live up to his responsibilities and obligations. Know what the variety is protected, whether it's PBR 91 or PBR 78. And then what agreements are in place? Is there an SVUA? Is there a patent, a contract, some other agreement? It's critical that you inform your customers, and really, particularly in the first few years as we get this new system rolling, just like the update to PBR 91, you as retailers have a critical role in informing your customers. So the Seed Variety Use Agreement was a genuine offer. It is a genuine offer made by the seed distributor and the seed developers to producers. It's an offer to put together two things that you do already with producers, which is contract, and one thing they'll do, which is grow their own seed. And it was developed using these three guiding principles you see on the screen: value, transparency, and choice. No one's expected to use a Seed Variety Use Agreement unless they want to, unless the variety provides value to them. And you'll know in a transparent way as the retailer and the seed buyer what the terms are when you buy. Under this agreement, the plant breeder will nominate his varieties into the platform. He will lay out what the seed variety use fee is for the use of any grain diverted for seed use. But producers will still have a choice. And it's important to realize that the SVUA system is only ever going to be available on varieties that are protected by plant breeders' rights, PBR 91. And farmers will still have a privilege of using their farm-safe seed. In the case of those varieties protected by UPOV 91, there will be a fee. To use that farm-safe seed in all other varieties, there will be no fee. So we've studied this problem for many years. We've been, as an industry, looking at other systems around the world. Our goal here is to move towards where 100% of the acres contribute towards plant breeding, which is not the case now. But what we've developed is a made-in-Canada solution. It's not completely like a system anywhere else in the world. It is going to be on a platform that's electronic, which will be leading edge, and it will be based on what the producer sees as value. So here's how it works in schematics. As a grower retailer, you will explain to the seed purchaser the variety, what its benefits are, and that it has a contract. The producer will have signed up with the platform, or you will sign them up as a retailer. And then once you make the sale, that contract will be applied to the producer's platform agreement. He'll plant that certified seed that he purchases. He'll grow it for a year. At the end of that year, he'll decide whether it's the variety he wants to continue on using, whether those are the genetics he wants, and then he'll divert some of his grain for seed use. Sometime in the next year, after he's planted a crop, we will contact him because we will know that he has a variety that's subject to an SVUA, and we'll ask him what he used. And based on what he says, he will receive an invoice. He will declare what he's got and he'll receive an invoice. And that process will repeat every year for every SVUA variety. It's important to note that the plan here is to have one contact point for the producer for all SVUA varieties. So in more written terms, this is how this works again. The steps are: producer buys certified seed of a protected variety. He electronically signs the SVUA at that time. Each year he declares what he used and the terms of the agreement, and then he'll be invoiced for what farm safe seed he's used. One invoice, all SVUA varieties. The SVUA platform is something that we're developing as an industry. This is a confidential database which is there to facilitate the transfer of correct information. So once a farmer's signed up to it once, he never has to sign up again, and then each of his sales are assigned to his system. The same master agreement is on the part of retailers. You will sign up as retailers once, and then you will be informed you are regarded to be informed as being able to present the information properly to the seed growers. So this maintains a single system, and this collaborative approach means that although a farmer may be dealing with multiple retailers and multiple companies, there is no danger of information being shared other than where the producer has agreed to. We will maintain confidentiality of transactions, so therefore, SeCan transactions, they're only known to SeCan and the farmer. Now, this is one of the places where we've learned a lot. We've learned a lot from the midge-tolerant wheat system, and what it means is that learning means we've got to do a lot of communication. So we will be doing large communication campaigns directly to the stakeholders involved, the distributors, the seed growers, the retailers, the producers. As well, you can expect that we are going to have a very large commitment to making sure everyone's living within the system. Invoicing, collection, and enforcement will be handled by a central agency and are not the responsibility of the seed retailer. As in the normal practice for CPTA when it comes to looking after intellectual property, our enforcement approach will be coaching for compliance. It'll start with education, as I said, communication, online training, things that we're doing to make sure that every stakeholder understands what's going on and what their obligations are. We will be doing some monitoring, and that monitoring will be around knowing the transaction that have taken place and checking to see if producers have answered their declarations and if they've answered them on the varieties that they have in place. We will also be doing what's known as graduated enforcement, and graduated enforcement quite simply is we start with informing and then questioning and then audits before anything in terms of any kind of more serious enforcement goes ahead. The plan here again is the same contact point system where a farmer may have 3 or 4 different companies that he's using SVUA seed, but it'll only be audited by the central platform auditors. So that's the system that we plan on putting in place. And again, the objective of enforcement is to change behavior. It's not about penalizing. It's about getting everybody on side. The audit will be done by trained independent third-party auditors. If there is an infringement of not paying a contract, then it'll be up to the seed company to decide how to negotiate the settlement. But really, it's their responsibility to do that, and the platform will enable that to be done efficiently and with great accuracy. So if and when we move forward with the SVUA, and the industry is working hard to get consensus from producer groups and government to move forward, the seed variety use agreement, which is a form of trailing royalty, will continue to work on its principles of value, transparency, and choice. As I said before, we look forward to working with you and understand that we have a lot of confidence that retailers have experience in contracting with producers for things like stewardship and traits. This is just an extension of the things that you've done in the past, and it moves it into an enhanced area, and the goal being to get more income for plant breeders and distributors to develop more improved varieties.
Thanks so much, Lorne. We'll now take some questions. If you have a question, please type it into the chat box. Again, if we don't have time to take all questions, you will receive an email response. Lorne, what's the biggest thing retailers should remember to do to ensure that they are making sure their intellectual property obligations are satisfied?
Well, the first thing in terms of retailers is you have to be aware of what you're selling and what the terms of sale are. So whether that's seed that has PBR on it, seed that is PBR and also has an SVUA. The second thing is to be upfront with the producer. Simply make sure that you're talking to the producer about it. Make sure you're accurate in your statements. And if you have a question, reach out and ask the company involved. Reach out to the CPTA or other people that have the information and talk about it. These kinds of changes, like we're talking about, take some time for everyone to get used to. That's why there'll be online training. That's why there'll be websites. It has to be talked about. It can't just be something that's going to happen later. Talk about it before you make the sale. Confirm it when you make the sale. Ask about it going forward. The more that retailers support this in a positive way. And understand that the reason we're doing this is today, direct payments to the plant breeder come only from pedigreed seed, and that amounts to 20 to 30% of the acres. And we need to have more acres contributing to have more money directed to public and private plant breeders to develop new varieties.
Lorne, regarding the SVUA or seed variety use agreement, should it come into effect, what are some ways that retailers can talk to their customers about this, and what can they do if a customer is uncomfortable with the idea?
Well, the first thing, as I said before, is if someone is just opposed to this and it's not a good option for them, you can actually put it in those terms. You can say, here's a new variety that you might like, but it has this characteristic that you may be opposed to. The retailer should simply say, I don't feel you're going to live up to the contract. If you're not going to live up to the contract, don't sign it. The second thing is just to be aware. 90% of the work we do in terms of serious infringements are because someone at the front line heard something or had something admitted to them. So you want to be aware of what's going on in your marketplace. You know your customers better than we do. Make sure you're aware. If something doesn't feel right, and I've said this to retailers before, if you get a bad feeling, even just take a day off and finish the deal later. Reach out and talk about your bad feeling with one of your supervisors or with someone like CPTA and say, I just get this feeling. 90% of the time, you know your customers so much better that you're able to make these things happen better. I think the other thing to keep in mind is to reinforce that this is about creating a bigger income flow so that more breeders will come in and essentially come to try to compete for the business. Canada today is very reliant on public breeding. We don't know what that means in the long run, but we also know that when you have more people competing for the farmer's business, more people competing for that sale of seed, that use of seed, the likelihood is you're going to get better varieties because they're competing to get that extra income.
Thank you very much, Lorne. Well, that's all the time we have today. If you had a question that we didn't get to, you will receive an emailed response. I'd also like to thank our sponsors one more time, 2020 Seed Labs, Canterra Seeds, and SeCan for their support. Again, this webinar will be made available on our website, germination.ca, within the next 24 hours. Thank you again for spending your lunch hour with us. This is Mark Zinkowitz of Germination signing off.